touching and lewd comments by Governor Cuomo.
The investigation includes reports of the governor groping, kissing, touching, and making suggestive comments to female employees.
Incident by incident, all of these allegations is an absolute bombshell. I've never really read something like it against a sitting governor. And to my mind, it's hard to see how Governor Cuomo persists with any kind of a political future based on the black and white of this report.
ABC News political director Rick Klein. President Biden once again urging Americans to get vaccinated against COVID-19.
Experts tell us that we're going to see these cases rise in the weeks ahead. A largely preventable tragedy that will get worse before it gets better.
An announcement's expected soon from the CDC, sources say, of a 60-day extension to a federal moratorium on evictions. If you want to dine indoors at a New York City restaurant, maybe see a show, work out at a gym, you will soon need to show proof that you've had at least one dose of a COVID vaccine. 2 people are dead, including the suspect, in a shooting at the Pentagon. You're listening to ABC News.
From the KMET Weather Center, for Beaumont, Banning, and the Pass area, we have an excessive heat warning in effect. This afternoon, sunny and hot, high 104. Clear tonight, low 76. Sunny and hot Wednesday, high 104. For the Inland Empire, we have a heat advisory in effect. Sunny and hot this afternoon, high 106. Palm Springs will have sunny skies. There is an excessive heat warning in effect, high 118. I'm meteorologist Jim Minali for Smart Talk 1490, KMET.
Your Pharmacy and Mobility Solutions now has Pack Your Meds. That's right, just add water. You order 5 or more prescriptions from Your Pharmacy and Mobility Solutions, and they will pack your meds for you in AM/PM marked packs. No more sitting down and counting and dropping them on the floor. You remember, it's not fun. I didn't like it. So now they'll do it for you. Safe, sealed, and dated. So call Your Pharmacy and Mobility Solutions at 951-845-8252.
The following is a paid program. Views and claims expressed are those of the program producer and are not endorsed by this station. Opinions expressed are not necessarily those of radio station KMET, its management, employees, or affiliates. The WK Law Power Hour is here to take you from zero to hero in legal knowledge in 60 minutes. A law firm with 40 years of experience is ready to give you legal guidance you need for free. What could be better than that? Amazing stories about actual cases, interesting and informative guests. Listen, watch, call in. Come ready to learn. And now your host for WK Law Power Hour, Paul Wallin.
Hi, everybody. This is Paul Wallin. I'm the senior partner at Wallin Klarich, and this is the WK Law Power Hour, where we say legal power is knowledge. The more knowledge you have in a legal situation, the more powerful you are to make the right decisions. You can go from zero to hero in 60 minutes by watching this program. Today we have one of our great senior associates on the show to talk about so many legal issues. I've been a lawyer for over 40 years, even though it's probably shocking because I look way younger than that, but it's all true. My lines on my forehead will tell you. And the whole purpose of this show is to give you guys legal knowledge that can help you, legal knowledge about pending legal issues, legal knowledge that can help you win in court. For example, we talk about how to win a traffic ticket and when you should set your case for trial. What do you do in a DUI case? Do you take the blood or breath or urine test? What about if you're going through a divorce? How can you maximize your chance to either raise your child support or lower your child support? Everyday issues that people care about. I think that's why I have thousands and thousands of followers on TikTok and many on Instagram, because they like getting free legal knowledge. And that's what we provide. And we also talk about the really, really important issues of the day. And the first issue that I want to talk about today is the recent developments with Governor Cuomo in New York. And the bottom line, and I'd like to get your opinion, and call in on the show, 951-922-3532, is he's being accused of sexual assault. He hasn't had criminal charges filed. He asked for a big report to be done. A big report was done and came back yesterday saying he did it. 156 pages. And he's being accused of sexual assault by many women. And he's saying, I'm a touchy-feely person. I'm a politician. I hug guys. I hug girls. I kiss girls on the arm. I kiss girls on the forehead. I kiss guys on the forehead. That's just what he does. He's Italian. That's sort of his defense. And so what is the response to that? Does he have sexual assault in his mind when he does it? What are we going to do? Brain surgery on him? The women say they were offended by it. They're saying he touched their butt. There's other things like that. But this isn't the kind of cases where they're talking that they took these women alone and he committed oral copulation or intercourse or those kind of things. So will he be prosecuted? Can he get a fair trial in this kind of environment with this whole Bill Cosby thing? Are they going to just say, well, Cosby did it, he did it? I'm just curious what you guys think, because fundamental fairness in this country requires that you do not convict people just because of something in the newspaper. And yes, with Epstein also, that's another thing. So if you'd like to talk about that, feel free. The other thing I want to talk about that's really, really important is this whole thing with the vaccines and the vaccine cards. Now things are getting really, really hot. People that don't want to take the vaccine, that's their choice. But now there's going to be a lot of punishment that comes with it. Major corporations are saying, you don't want to take the vaccine? Fine. Don't come to work. Work from home. Unless you have a good excuse, like a medical excuse, your doctor says don't take it, you're screwed. And you're going to have to not get a job. And then how about New York City? You live in New York City, and in about a week, this new law is going into effect that says you can't go to a Broadway show, you can't go to a Knicks game, you can't go to any sporting event, and how about this? You can't go into an inside restaurant unless you walk in with proof of vaccination. So what's next? When will people say, wait a second, okay, I'll take the vaccine because I know it's in the best interest of other people and myself. What is it going to take? How much more does the government have to do? In California, you've been told you cannot get into school, into college, state college or a university. You can't walk on a campus in California unless you have proof of vaccination. It's going to continue, people. While the beds fill up in Louisiana and Missouri and the infections go on in the red states because a small amount of people are vaccinated, it's happening right in front of our face and our noses. Yes, less people are dying, but more and more people are becoming infected. Children are becoming infected because they haven't had the chance to get the vaccine. And you, whether you're selfish, whether you are waiting for the FDA approval, that's on you. But don't blind yourself to the reality that you could be causing serious damage to someone else because the Delta variant is extremely contagious. 100 times, they say, more contagious than the last one. So you guys are going to decide, the ones that won't get a vaccine, you guys are going to decide what happens. And what I want you guys to know is I'd love for you to call in after the break. Greg Balderrama from our office, a brilliant criminal defense attorney, is going to be answering a lot of questions. We'll take your calls. And I just want you to know, please consider what I'm saying and call in and we can talk about anything. I don't care if you agree. After the break, we'll talk more.
You've been charged with a crime, and now you're facing the loss of your freedom. Where do you turn to get out of jail or stay out of jail? The law offices of Wallin Klarich. Call 877-4-NO-JAIL. With over 20 years' experience and attorneys who work in your local courts, Wallin Klarich can make the difference between jail and freedom. When you need help, make one call. Make it to Wallin Klarich. 877-4-NO-JAIL. The call is free. Will you be?
Hey, are you okay to drive? Yeah, I'm fine.
17 to Central Jail.
If you've been arrested for DUI and are facing DMV and court hearings, it could mean losing your license, your job, and even your freedom. But Wallin Klarich can help. Just call 877-4-NO-JAIL. With attorneys who know your local courts, Wallin Klarich can make the difference between jail and freedom. Call Wallin Klarich at 877-4-NO-JAIL. The call is free. Will you be?
When your children are taken by social workers, it may be the worst day of your life. When will I see my children again? Where are they going? How can I get them back? Who can I turn to for help to end this nightmare? The answers to all these questions are a phone call or email away. Wallin Klarich have been helping defend parents who are battling the system to regain custody of their children for 40 years. Many of their clients have done nothing wrong to warrant their children being taken from them. Other clients may regret some action that they've taken with their children. However, in every case, the clients desperately need their children back. That's where Wallin Klarich comes in. They know the dependency system. They will do all they can to work to try to get your children back with you. Take the first step and call Wallin Klarich now for a free phone consultation at 877-466-5245. That's 877-466-5245. Or visit wklaw.com to chat with us. They'll be there when you call.
If you are facing criminal charges, your entire future is at stake. You need to act now to protect your job, your family, and your freedom. Call Wallin Klarich at 877-4-NO-JAIL. Wallin Klarich has over 30 years of experience in fighting for our clients' rights. With local offices in Riverside and San Bernardino, we are here to help you now. Call 877-4-NO-JAIL or go to wklaw.com. How much is your freedom worth? Call 877-466-5245. The call is free. Will you be?
When you have a warrant for your arrest, it's a very scary time in your life. When you drive a car, you have to be extra careful that you do not commit any sort of moving violation. You have to be looking over your shoulder, checking for police officers. Will you be stopped and thrown in jail? What a horrible feeling. For over 40 years, we have helped thousands of persons resolve their problem with having a warrant. In some cases, we can actually appear in court for you without you being present to recall the warrant. Depending on the facts of your case, you may never have to do 1 minute in jail. Stop living in fear. Call us now for a free phone consultation at 877-4-NO-JAIL. That is 877-4-NO-JAIL. Or go to wklaw.com. Isn't it time to get your life back? We will be there when you call.
Hi, everybody. We're back, and it is my great honor to welcome Greg Balderrama, Senior Associate at Wallin Klarich, to our program. And Greg is going to talk about a lot of very important legal issues that affect so many people in our country, especially in those in California. A lot of different topics we're going to cover. How you doing, Greg?
I'm doing well, Paul. Thanks for having me on.
Sure. Welcome to the show. Greg, I'd like to first of all get to know you. I'd like the people on the program to get to know you and your background a little bit, to figure out how you ended up at Wallin Klarich and your passion for what you do. So why don't you start telling us a little about where you grew up and where you went to school, and we'll go from there.
Well, I'm from Los Angeles, born and raised, and I'm proud to say I went to UCLA for undergraduate.
UCLA graduate, that is the best. Go Bruins. Go ahead.
Bruins. And then, of course, I went to Loyola Law School, so I couldn't be more Los Angeles than that, really. While at Loyola, I had the honor to work at the Major Frauds Unit at the Los Angeles County District Attorney's Office, a very complicated area of law, and interested in criminal law, and that was a great way to get some experience. After passing the bar exam, I was very fortunate about 5 years ago to find Wallin Klarich, and I've been here ever since, and handling misdemeanors and traffic, and then eventually moving up to serious misdemeanors and felonies, and then of course handling all the other criminal adjacent types of areas of the law. And it's been just a tremendous experience.
So you've been with Wallin Klarich for about 5 years, Greg. Can you tell me, what is it about criminal defense? Why did you choose to represent people that are accused of crimes as opposed to doing any kind of area of law?
Well, I always say that the thing about criminal law, why do you do it? I feel like, well, it's never boring. That's the first thing. Law can be extremely boring, or just, you got to do something you love if you're going to put that much of your time and have that much student loan, I would imagine. So at the very least, let's do something we like here. criminal defense to me, it's no different than any other area of just caring about your clients. I really enjoy helping people, and I think criminal defense is just your opportunity to kind of help people from all different walks of life. Or other areas of law will probably be more focused on certain types of economic brackets. And with criminal law, you take them as you find them, but they're going to be from just across different different types of people. And I like helping out people. What I tell people the most about why I'm choosing to help them is I don't think necessarily my clients are bad people. They might have just had a bad day, and the vast majority of them are going to be first timers, and I'm just trying to help them fix their life down the road. And if not today, then at least 5 years from now, and they can fix whatever it is that's got it to this point.
A lot of people ask me and all criminal defense attorneys, how can you represent someone that you know is guilty? Let's say someone that you know is guilty of drunk driving, and he's got 2 kids and a wife, and how come it's easy to represent someone accused of drunk driving?
Right. Well, it's never easy. There's always going to be something I have to consider. There will always be a consequence, but it's not that simple for me to decide someone's guilty, or for the district attorney's office or the city attorney's office, whoever's prosecuting them. It's not for them to decide who's guilty. That's the whole point. It might be that this person ends up getting convicted for whatever reason, and there's little I can do about it. But it should never be as simple as somebody saying you're guilty and that's it. And even if they are necessarily guilty of one charge, that doesn't mean they're guilty of all of them. And in any case, like I said earlier, if there's a situation where, this is a first timer or second time, whatever the case may be, I try to show them or convey them to a prosecutor, again, that they're not a bad person. They just had a bad day. So let's not destroy their whole life, because they only get one life to live, as far as I know. And my job is to help get them back on that track.
So basically what you're saying, I think, is that the fact that someone's accused of a crime, even if it's a serious crime, he has the absolute right to the best defense possible, because the district attorney may be asking for 9 years in prison, right, and our client might have a wife and 2 kids and so many things going for him, but he just did something bad, really bad, on one day, and our system of justice would fail if you just automatically gave someone the maximum and gave no chance to rehabilitate themselves, right?
Right, exactly. And I mean, and for people who say they honor the Constitution, it's not my rule. It's right there in the Constitution. It's Fifth Amendment right, due process, Sixth Amendment right to an attorney, and that's part of what I'm trying to do is make sure that these fundamental rights of ours are respected. And if without this side of the law, it wouldn't be anything. It would just be some rules thrown together instead of fundamental rights. So
Governor Cuomo, you've heard, I'm sure, that Governor Cuomo in New York is being accused of sexual assault. Many women have come forward over the last several years to say that he touched them inappropriately. He's saying that he loves touching people, and he kisses people on the cheek, and he hugs them, men and women. And so in a case like that, right, would we be able to take on a case like that if Governor Cuomo came to us and says, I did not touch anyone with sexual intent?
Yeah, well, yeah, absolutely. He has absolute right to representation and to have his day in court. What he chooses to do from a political standpoint, that's up to him and his advisors. But we would absolutely recommend that let's explore this, find out what our defenses are here. How can we address these things?
Right, and it's important that people realize that the fact that someone is accused of touching someone, even if it's on their back, even if it's on their butt, even if it's on another part of their body, that's not enough to convict someone. You have to prove that the person's actions were done motivated because of a sexual intent. And the jury has to find him guilty unanimously, all 12 people, beyond a reasonable doubt. And especially if someone has no prior sexual history of doing anything like this, it's not very easy for the district attorney necessarily to get a conviction, right?
That is correct. Absolutely.
Yeah. Okay, so the next thing I'd like to talk about is something really important to all adults who might end up on the child abuse Central Index. Can you first of all tell us what is the Child Abuse Central Index and why is it something you don't want to be on?
Absolutely. This is something that's very specific to California. Child Abuse Central Index, we abbreviate to CACI, C-A-C-I. It's a very unique area of the law. A lot of attorneys don't know about it. It's not a criminal prosecution, although it's generated by a criminal accusation of some kind. And how this becomes an issue is when a social worker is somehow notified of some kind of child abuse, either neglect, physical abuse, mental abuse, or sexual. And typically what happens here is mom and dad or whomever get into an argument, some kind of physical dispute, and the child is physically present, or child gets hit while they're arguing. And it's the job of the social worker to make sure that this child and this parent, are properly notified about that's not okay. But it can also happen if someone's neglectful, say they aren't feeding their children enough or clothing them, and certainly sexual abuse would definitely bring you to their their crosshairs, so to speak. And it's bad because the social worker has a lot of power. I know we're going to do dependency shows, but they can start the dependency case. They can notify they're supposed to notify the police about a criminal accusation, and in this instance, they can on their own decide to place you on this CACI listing. No court, no really any true investigating other than just speaking to the victim, and that's it. They put you on this listing. And it's serious because its job is to prevent you on this list from getting employment that would place you in a position where you can get access to more children. So a teacher, nurse, doctor, counselors, those are the big ones. You can never have those jobs because it will be on your background checks. So it's very
social. One second. So the social worker, just upon getting the accusation that someone alleges that you touched a minor, say inappropriately, or you physically disciplined the minor, they have the power to put you on this list without anyone else making that decision. Just a social worker can do that.
That is exactly correct. They don't even necessarily need to speak to the accused.
No due process. Nothing.
No,
you're already on the list.
That is
and then what? Then they have to send you a letter telling you're on the list, right?
Correct. And then you have approximately 30 days from the date of the mailing, not from receipt, to request this hearing. And that's supposed to be where your due process rights kick in. You're on the listing until you're pretty much guilty until proven innocent in this issue. Really.
Right. And so, hi, Toe. How can we help you today?
Hey, how you doing?
I'm doing fine. How are you doing, dear?
I'm doing good. I'm sick, so if I don't talk right, I'm paralyzed.
That's okay. What would you like to ask or say?
I came home from the hospital about 3 days in June.
Uh-huh.
And the welfare people came out here and took my daughter.
Huh.
And they didn't give me a reason why they took my daughter. And they took my grandchildren.
Huh. And are they still not back? You still don't have them?
Sir.
So this kind lady from Georgia is calling and saying that she was in the hospital for 3 days, and while she was gone, they took her children and her grandchildren, the social workers did, and she still doesn't have them back. Is that right, ma'am?
Yes, sir.
Well, what you need to do, ma'am, is you need to get a lawyer in Georgia now to go and represent you in court and argue that you're a good mother and a good grandmother, because I assume you are, right?
Yes, I am.
Yeah, and the fact that you have a physical disability doesn't disqualify you so long as you have help to watch these kids. This must be horrible for you. And we have so many cases like this where parents lose their kids and we fight to get them back. Even when the parents do make a mistake, we get them into the proper therapy or the proper programs so they learn properly so they can have their children. Because sometimes the harm done to these kids being ripped away from a wonderful woman like you is worse than whatever the social workers are worried about. How often do you get to see the kid? How often do you get to see them now?
I don't see them.
They don't even give you visitation?
No.
Ma'am, please call a lawyer in Georgia. You can find one and tell them your story, because we're in California, so we can't represent you. We only can do these cases in California. But please get a lawyer in Georgia, and I pray that you get a successful outcome, okay?
Yes, sir. Now, I'm going to tell you, my grandchild, so happened she was in town. And it was her kid. So they took her kid and mine. And they didn't give us a reason why they took them.
It's almost like they don't treat people like human beings sometimes, or they don't understand the importance of the relationship between a parent and a child, or a grandparent and a child, or the bond between the parent and the child or the grandchild. Yes, okay, the house is dirty, I get it. Or yes, the person doesn't have a lot of money and they may be on food stamps, but they still love their child the same as a person who's rich in Beverly Hills. And I feel very bad for you, ma'am, but we got to go to the next call. So thank you for calling, and I wish you the best of luck, okay?
Thank you.
Thank you, dear. Okay, so Greg, getting back to the CACI hearings, and ironically, this woman calls, and it's very similar to what we deal with all the time. The penalties, again, for being on CACI is that if you're put by a social worker on CACI, you're not allowed to then have a job that has anything to do with where children are involved. Is that right?
You also won't be able to adopt or be a foster family if that's something that interests you. But
okay, but we've handled many of these cases successfully, right?
That is correct.
Okay, and how do we go about doing that? How does the process start? Once the person gets the letter that they're put on CACI, they contact us, and then we demand a hearing, right?
That is correct. And again, those are really strict deadlines. 30 days from the date of receipt, you must request the hearing. You don't necessarily have to set the hearing within that, but at least request it. And at which point then you have some other steps you need to follow, because it's not just enough to request it. You got to start preparing for it. And that's where you would need an attorney to at least assist you with that. Unfortunately, this isn't somewhere the public defender's office can help you. You will almost certainly have to either represent yourself or hire a private attorney to do this. And it's critical that you have one who's experienced in handling these kinds of things.
And if a person hires us to try to get off this CACI list, then we have the right to call witnesses at the hearing, right?
Absolutely. Unfortunately, your subpoena power is very limited. This is not a case that's heard before in court or before a judge. It's typically done in a conference room and presided over by a judge, but not necessarily someone who went to law school. It's somebody presiding from the county. This is a grievance hearing officer. And you don't have subpoena power to bring any witness you want or any evidence you want. You do have a right to review the social worker's reports, which are comparable to a police report. It's confidential because it involves minors, so you have to request that and make sure you've done that correctly with the proper the children's courts, the dependency courts, of course. And then at that point, you would need to prepare your whatever witnesses that you would have to bring in voluntarily. You could testify on your own behalf, but because a lot of times there's some potential criminal accusation attached to it, you should once again consult with an attorney, because anything you say would be done under oath. It's recorded. It might find its way to a prosecutor's office. So there you need to be, very mindful of those things.
So if you get that letter that you've been put on CACI, you must act quickly. You must call us. We'll get you a hearing. We'll demand a hearing. And if we win the hearing, then you're removed from the list, of course, right?
That's correct. You got there's 2 ways out of 3 ways you can possibly win this. One is if it's unsubstantiated, which means the social worker reports is just not true, or inconclusive, meaning maybe this happened, maybe it didn't. Tie goes to the runner of the client, so you'd be off for that reason. The third reason possible outcome would be it is substantiated, and then you're essentially left in the same position you were when you were first put on.
Got it. Okay, well, we've talked about CACI. If anyone has a child abuse grievance hearing, call us. We'll be glad to talk to you for free. We're going to go to the commercial break, and afterwards we're going to talk about another very interesting area of law with Greg Balderrama.
You've been charged with a crime, and now you're facing the loss of your freedom. Where do you turn to get out of jail or stay out of jail? The law offices of Wallin Klarich. Call 877-4-NO-JAIL. With over 20 years' experience and attorneys who work in your local courts, Wallin Klarich can make the difference between jail and freedom. When you need help, make one call. Make it to Wallin Klarich. 877-4-NO-JAIL. The call is free. Will you be?
When your children are taken by social workers, it may be the worst day of your life. When will I see my children again? Where are they going? How can I get them back? Who can I turn to for help to end this nightmare? The answers to all these questions are a phone call or email away. Wallin Klarich have been helping defend parents who are battling the system to regain custody of their children for 40 years. Many of their clients have done nothing wrong to warrant their children being taken from them. Other clients may regret some action that they've taken with their children. However, in every case, the clients desperately need their children back. That's where Wallin Klarich comes in. They know the dependency system. They will do all they can to work to try to get your children back with you. Take the first step and call Wallin Klarich now for a free phone consultation at 877-466-5245. That's 877-466-5245. Or visit wklaw.com to chat with us. They'll be there when you call.
Hey, are you okay to drive? Yeah, I'm fine.
17 to Central Jail.
If you've been arrested for DUI and are facing DMV and court hearings, it could mean losing your license, your job, and even your freedom. But Wallin Klarich can help. Just call 877-4-NO-JAIL. With attorneys who know your local courts, Wallin Klarich can make the difference between jail and freedom. Call Wallin Klarich at 877-4-NO-JAIL. The call is free. Will you be?
When you are facing a serious criminal charge, it means you may be looking at many years in prison or doing up to 1 year in county jail. Most people do not know who to turn to in their time of need for expert legal guidance. What you do next can make the difference between ending up in prison for many years or having your charges dismissed and you going free. At this very critical time in your life, you need Wallin Klarich fighting for you. Wallin Klarich has 40 years of criminal defense experience, and they work very hard to do all they can to win their clients' cases. Wallin Klarich has a team of 10 criminal defense lawyers fighting for their clients every day. They help people with cases pending throughout California. They successfully defend cases dealing with murder, sex crimes, all felonies, as well as misdemeanors. Check out wklaw.com for some real client success stories. They offer a free phone consultation to answer your questions. Call them toll-free at 877-4-NO-JAIL. That's 877-4-NO-JAIL. They will be there when you call.
If you are facing criminal charges, your entire future is at stake. You need to act now to protect your job, your family, and your freedom. Call Wallin Klarich at 877-4-NO-JAIL. Wallin Klarich has over 30 years of experience in fighting for our clients' rights. With local offices in Riverside and San Bernardino, we are here to help you now. Call 877-4-NO-JAIL or go to wklaw.com. How much is your freedom worth? Call 877-466-5245. The call is free. Will you be?
Okay, guys, we're back with Greg Balderrama talking about some really interesting legal issues. And the next topic we want to talk about is what happens when a person who is in this country and is accused of a crime, but at the time he's not a citizen, and he pleads guilty, and his lawyer did not advise him that if he pleads guilty to that particular crime, he's going to be deported and sent back to his country, even if he has a family here, even if he has a job here. So, Greg, can you explain a little bit about how that process works?
Absolutely. So when we're saying non-U.S. citizens, we literally mean that if you have not naturalized. So if you do have some kind of protected status, be it a green card or asylum or what have you, you still are under this umbrella. So I want to be very clear. If you're not a U.S. citizen, then this is going to apply to you. Obviously, if you have no protected status, you're here undocumented, that's dangerous in and of itself as far as being deported. But where crimes are involved, well, you do have rights by being in this country, even if you aren't a U.S. citizen or have no protected status at all. And it's important for you to understand that certain types of crimes will be deportable and can also lead to you being denied naturalization permanently. And that's where two important penal codes come into play here. Penal Code 1016.5, which requires the courts to advise you of the potential immigration consequences by law. And that's if you could be denied naturalization, you could be denied reentry, and you could be deported as a possible outcome. That's all the court needs to do. But they weren't really doing a good job of that until maybe over the last 15 years, they've gotten a little bit better, but sometimes they make mistakes. And if you don't know that, you have the right to file a motion to withdraw your guilty plea. And it sets you back to, step one. And that conviction is technically removed from your record. And you can do something and hopefully plead to not something that won't have those consequences.
Let me ask a question before you go to the next one. So if let's say you're not legal, you have a green card, and you've been here for several years, and you have a lawyer, and the lawyer says, you know what, I've got a good plea bargain for you, and you accept it, and he doesn't tell you, by the way, you could be deported. So you say, oh, great, I'm going to get out of jail, I'm going to be on probation, and then they hire us. Well, how do you find out what happened back then? How do you get the records?
Well, there's sometimes, it depends on how old the case is. A lot of times it gets destroyed, but you should at least attempt to see if it's been, if you're in Los Angeles County, then you go to the Los Angeles archives and you try to pull what you can. Contact a court reporter if they're still practicing, and sometimes it's say it like this, but still alive. I've had to go and request court reporters' transcripts from the late 80s, and somehow, some way, she still kept them, and it was very helpful. And or you try to get a copy of the actual docket and see what was stated there. But if your attorney straight up tells you or doesn't check on the immigration consequences, that's a very serious offense called ineffective assistance of counsel. And that's where the newer penal code, 1473.7, picks up. You don't need to show ineffective assistance of counsel any longer. That was amended a couple of years ago. All you need to show is that you did not, at the time of your plea, meaningfully understand the immigration consequences. Of course, the district attorney's office is always going to be of the opinion that that you did, and they can point to certain areas of the record. But that's still not enough. Even if you did get the advisements from the court necessarily, you could still challenge it by showing something that maybe you had a job here, maybe you had a property, your children were born here. You had all of these things to lose. Why on God's green earth would you decide to agree to something that's going to that lead to such horrible consequences? Sometimes it's not even the potential jail sentence that they care about. It's 6 months would be fine if I don't get deported. And if the if the attorney does not even consult an immigration attorney to figure out what those are, then they've committed a very serious offense. Admittedly, immigration law is confusing. It really is. But that's our job as criminal defense attorneys to figure that out by talking to someone consult with them.
Can we still bring the motion to set aside the person's guilty plea if all of a sudden he's facing deportation, even if he's already finished his jail time and he's out of jail? Can we still bring the motion?
Absolutely. In fact, that's almost certainly what happens. They finish their probation. Years later, they find out one of several ways. Either they go to renew their visa and they find out for whatever reason that they are not eligible for it. And that could be 5, 10, 15 years later. But, or they just find out that they are on ICE's radar and they get deported. They go home to visit somebody and they can't get back. That's how they find out. And the laws were written so as to address those things.
And we've had successful results when people have hired us to withdraw their pleas?
Yes, we've been very successful. I have one worked out in a couple of weeks. We're under the immigration advisements from the court, and talking to the prosecutor there, seeing what they're willing to do with us. I got to say the Los Angeles ones are very understanding about this. Some of the other prosecutors are as well. They don't, again, this goes back to our original topic of They understand that this person may not be a bad person, especially if I can show 5, 10, 20 years of good behavior since this conviction, and we can work those things out. And we have a pretty good success rate.
That's great, because so many people don't know where to turn when they have such a situation, and they can turn to Wallin and Klarich because we've done this successfully so many times. I'd like to turn to another area that we get calls on every single day, that the average person in the United States, and definitely in California, comes in contact with. A lot of people are involved in this. That's restraining orders. Can you tell me, we represent people, obviously, who are facing restraining orders, right?
Absolutely. I would say.
You've handled many of those cases, right?
Right. This is that criminal adjacent area of the law that we handle. It's technically family law, but it's generated from a criminal accusation of some kind, even if it doesn't get filed in criminal court.
First of all, can you tell us what are the consequences to, say, a father, and he has a couple kids, and his ex-wife files a restraining order against him, saying that he needs to be restrained from both her and the children. What are the consequences if the restraining order is granted?
Well, number one, it would definitely affect any type of custody issue. That's number one in the family law context. And again, going back to what we were originally talking about with the CACI or dependency cases, that certainly could play a role in, as far as parental rights getting suspended or terminated if it's bad enough. The social worker will almost certainly require one of the parents to file a restraining order on the other or face losing one or both, or how many children you ever have. That's, again, how much power the social workers have. And it also kind of connects to what we're talking about with the non-citizens. Having even a restraining order not even generated from criminal court can be used against you should you try to apply for citizenship, believe it or not, even though it's not a criminal conviction. So, if you're into, if you have gun rights, if you're a police officer of some kind or in the military, that could affect you because you're not allowed to own, use, or possess a firearm while you have a restraining order on you. So there's really a lot of reasons not to just let this go.
To summarize a little what you said, number one, if you want to possess guns, any kind of guns, and a restraining order is granted against you, you must turn over those guns to law enforcement or destroy them, right?
Or sell them, but in any case, not be in possession, yes.
Okay, that's number one. Number two, if you're involved in a child custody battle and the judge grants a restraining order against you, it's going to be almost impossible to gain custody of your kids, right?
That is correct.
And also, another ramification is if you get the restraining order against you and that same person who brought it claims you violated it, then what happens?
Oh, that would lead to criminal prosecution because now you're effectively in a contempt. You're violated a court order. What people need to understand, though, with restraining orders, it restrains the person accused. It does not restrain the person who made the accusation. And a lot of times, people who have the restraining order, the temporary or permanent one granted against them, think that, let's say their partner, their spouse, calls them up and says, this was a mistake. I'm going to tell the judge this, and I want they have this removed. I forgive you. They respond in any way, shape, or form. They have technically violated the restraining order. And yeah, this person may have started the conversation. Nevertheless, you're the one who's going to be in trouble for it. And that's just how it goes. That's because they're not the ones who are ordered not to do this. And a lot of people make that mistake.
So what are the consequences criminally if you are prosecuted for violating a restraining order? What can happen to you?
It depends on which direction the prosecutor wants to go. If they want to say you violated a domestic violence restraining order, that could be a felony or a misdemeanor. They could also charge you with another theory called contempt. Either way, it's a criminal accusation. And now you find yourself in criminal court based upon some family law court order. And, based upon what could be just normal disagreements between, two people who had a dating relationship. Your job there at that point is to contest it in court. Otherwise, if you don't show up to court, chances are it's going to get granted against you. And now you've got this hanging over you and all the consequences we discussed, not to mention the potential criminal prosecution should you inadvertently violate it.
If you are prosecuted for that crime as a felony, you can face, up to 3 years in jail?
That's correct.
And if it's a misdemeanor, what, up to 364 days in jail?
That is correct. Not to mention the fact that you would also lose your gun rights there as well if that's your thing. So.
Yeah. So if in fact you've represented many people facing that crime, and could you tell us an example of after someone hired us facing jail time, how you were able to successfully have the charges dropped?
Well, I actually had a matter out of Orange County where an individual was accused of violating the restraining order by his girlfriend, who wasn't even present to witness this. It was her landlord who told her that he believed that my client was there, and she went and told the policing agency, and they charged him with violating the restraining order. He was adamant that this was not true. It literally took me having to show my client's that he was working at that time. This is before COVID, so no one was working at home. I had to literally show his electronic employment card that showed that when he was literally logged in, it would have made it impossible for him to go from his place of business to her home, get back in that time frame that they were saying. And he's very fortunate. A lot of people's employers don't keep those types of records. Nevertheless, we did. It was otherwise it would have been a triable issue, and he would have to just prove it to a jury that he didn't violate it. And we were able to get the city attorney to drop those charges. It was a very good outcome for him. I was very happy for him.
Another area of law that I want to discuss with you that we handle a lot of is if you have a driver's license in California, and there are many ways, if you have a driver's license in California, where you can lose your license, and you may not know about it. Can you just sort of tell us a list of the different ways you can lose your license in California? Might shock people. Right.
Well, the first one we always know about is the DUIs. You get convicted of a DUI or lose the DMV hearing, you're going to get your license suspended for at least anywhere from 4 or 6 months, or if you have priors, then it could be years. But those aren't the only ways. That's just the primary criminal way. And one way that people are really shocked to know is if you pass out or have something called a lapse of consciousness. You may be surprised to know this, but that's one area that's not confidential by your medical provider. They will, if an ambulance responds and you've passed out in the shower, or you passed out on the road, or if you just let your doctors even know that you passed out not even driving, they have a duty to inform the DMV, because that's a big concern. You can whether you're passing out from narcolepsy or hypertension or diabetes or whatever, the DMV is going to suspend your license for at least 90 days. And now you have to go turn around and request another type of hearing to get evaluated to show that either it was a one-time event or you're taking the proper steps to take care of that, and you're now adhering to your medication. So it's very important, not for all of our listeners here to understand that that's one thing you need to be mindful of. And of course, the other way is if you incur several moving violation points over a 12-month period I believe is that's important. And otherwise, you could potentially be suspended for a period of 6 months after a negligent operator hearing, which is again another DMV hearing that you would have to request and be successful. And we're proud.
Let me just stop you for a second.
Sure.
Are you saying that if a 35-year-old guy is in the shower and he just passes out, and they don't know why, but he just passed out, and his wife or girlfriend or someone calls 911, and the paramedics show up and they take a report, and then they revive him, or they don't, they take him to the hospital. Either way.
Right.
He can lose his driver's license even though he wasn't driving and didn't do it driving?
That is correct, because the concern here is you have a license. If this condition isn't either evaluated or diagnosed or addressed, if it is diagnosed, the concern is you could fall asleep or have some kind of even a momentary loss of consciousness, and it's a danger to society. And you don't want people falling asleep at the road like that or passing out like that, because it's dangerous for them. It's dangerous for all of us. So you understand where they're coming from. Nevertheless, it's important that you at least address it, because you have rights. And if you have a condition, well, first of all, get diagnosed and then address it. And that's the best way to try to deal with this. But in the interim, you're going to have your license suspended. And it's important that you recognize that that this is serious, and you should at least speak to an attorney about what your options are.
And in these kind of cases, people call us all the time, and they're shocked, and we take on the cases, and we have been able over the years to get back literally hundreds of people their driving privilege after this happened by having them go to a doctor, be evaluated. Then we get a report from the doctor. We show it to the DMV. And sometimes the doctor doesn't even have to come to court, but sometimes they do. And sometimes we have to have a full-blown hearing in the DMV office to get our clients their license back. Because in California and in most states, you can't get around much without a license. You can't get to your job. Right. And so such an unknown area of law that we handle, if God forbid you know someone and you're listening, we sort of are really, really qualified to help you in that kind of situation. And one more thing I want to cover with you that we didn't bring up yet, and that is senior citizens. Senior citizens are over 65 or 70 who are driving on the road, and a police officer stops them because they're driving too slow. And the next thing that happens, the officer turns them in to the DMV, and this person who maybe their last thing of independence and freedom is being able to drive to the store and do their grocery shopping, maybe drive their husband to the doctor, maybe drive themselves to the doctor, all of a sudden they get a letter that their license is being suspended. Can you imagine the effect on that senior citizen? Well, we've represented hundreds of senior citizens, and we have been successful in getting licenses back for people, in one case, as old as 92 years old. So I just want to warn you guys, this happens. And if your mom or you are listening to this and you have that problem, Greg, can you tell us how we handle those cases?
Absolutely. Again, it's important. It's going to begin with the doctor getting diagnosed and figure out, again, was this a one-time event? Then, of course, we explain that to the DMV. If it's part of a situation, a diagnosis, then let's diagnose it. For one, it's good for the person. And number two, we can also show the DMV how they're addressing the situation, why this won't happen again. So yes, it's critical that especially our older listeners understand that, because, driving independence is important, but, you also want to be able to take care of yourself. You don't want to, maybe you don't have anybody else but you, and you don't want to pay to go live at a in-home living facility or something to that effect. So it's critical. So you do have rights. You should consult with an attorney and, find out what's the best scenario for you to pursue your rights.
I think people don't understand that sometimes the best drivers, they may be 78 years old, and then they get this letter, and they come into the office or they call us, and we say, well, what's your driving record like? And they go, well, I've been driving for 60 years, and my last ticket was never, or my last ticket was 32 years ago, and they remember it they knew exactly what they were doing. And now all of a sudden they go from that to being told by the DMV, sometimes cold, heartless human beings, I'm sorry, that we're taking your privilege away. Now I get they're worried about some innocent person driving, getting hurt by this person, but they don't even take into account in some cases the person's a very good driver, always had car insurance, and now they're struggling, and the emotional damage that this causes to senior citizens when this happens is overwhelming. And this is something we pride ourselves in doing, treating senior citizens like wonderful people and doing everything to calm them down and helping them in this kind of situation. Greg, I wanted to, first of all, thank you for coming on the show. I wanted to tell people that if they are lucky enough to have Greg Balderrama as their attorney, they would be absolutely luckiest person, because not only is he a great lawyer, not only does he know the law, but he's just a nice human being. And that's not easy to find in lawyers these days. And that's why at Wallin Klarich, we try to find nice human beings to help people who are really, really stressed out. And Greg, thank you for coming on the show. I really appreciate it. And can you agree to come back?
Absolutely. Whenever you want me back, I'll be happy to be back.
Great. Okay, well, everyone, have a great week, and we'll see you next week with another lawyer at Wallin Klarich.